Giridhar Garu, former District Judge of Visakhapatnam District Court, and now Chairman, Net Visakhapatnam. I welcome both of you, sir. As part of this Saturday lecture series, we are inviting jurists, advocates, judicial officers in general and judges from Andhra Pradesh High Court. So in the process, we approached Justice Lakshmana Rao and requested him to visit DSNLU and give his valuable message as well as inspiration to our students. So I requested him to give orientation lecture. So he readily accepted to give a lecture on justice education, need of the hour. Now we know legal education, popularly known as after the advent of British rule and the Commonwealth system introduction in the country, we have the British criminal justice system introduced, particularly from 1773. Of course, mayor's courts at Bombay, Madras, Calcutta. Then after that we have 1773 Regulating Act. Thereby, Supreme Courts were established at Calcutta, Madras and Bombay. And the Governor General of Calcutta was made as superior, and governors of Madras and Bombay presidencies are under the control of Governor General of Calcutta. Previously they had some better occurrences among the indiscipline among those governors. So Regulating Act 1773 brought some uniformity in the administration among the East India Company's rule. So Lord Impey was appointed as the first Chief Justice of Calcutta Supreme Court, and we all know Rajananda Kumar, case in Patna, case in Kajura case. Then Cornwallis reforms are there in 1780, and we have 1833 charter, under which the law commission, first law commission was appointed. So slowly under 1861 Councils Act and High Courts Act 1860. So from High Courts the direct appeals are to the Privy Council until 1935 Government of India Act. So under 1935 Government of India Act, Federal Court was established. So appeals from the High Courts to the Federal Court to Privy Council. This was the brief legal history, and at the simultaneously we have the constitutional history also, and ultimately we had the freedom and we have Constitution of India, and the values for which the Indian society fought against the Britishers were realized in the democratic process introduced through the Constitution of India. So generally we are talking about the legal education. So legal justice and natural justice. So legal justice oriented administration of justice was generally practiced when there was a conflict between rule of man and rule of law. Rule of law prevails. Howsoever you are high, law is above you. So when there is a conflict between rule of law and rule of life, so So in the modern interpretations and justice delivery system, the judicial process, the dynamics of the courts started giving preference to rule of life. So when there is a conflict between legal justice and natural justice is preferred. So in the process, several movements were also there. How the legal education was started in India, we know, Vakil, pleader, barrister, different nomenclature were there for the practitioners of the court. So under Advocates Act, we have uniformity, that we have the advocates now. So Bar Council of India, various bar councils of the state, and all these are there as the regulatory bodies to administer this legal profession. So the judicial process is part of legal profession, and we all know different what we say ideologies, different understandings of the issues. So ultimately the court has to understand. That's why that is what is the trend developed in America, which is also practiced in India also, because there is no systematic research, there is no that much environment to have the research to understand the real behaviorism, the impact of behavior of the judge on the decision. Of course, in practice we had several examples, but there is a tremendous scope for the researchers to do the research on understanding the jury matrix in Indian context also. Jury matrix in American context was already developed. In Plessy versus Ferguson, the equality was understood by the judges in such a way, equality but separate was equality. Equality was there, but separate treatment between whites and blacks was the decision of Plessy versus Ferguson in 1870s. Until 1958, in America, equality was not implemented in its true sense. In Brown versus Board of Education, in 1958, 6 months prior to the delivery of the judgment, all the 7 judges, out of which 6 judges are white, 1 judge was black. The jury matrix, studying the behavior of the judges and understanding the judgment which is going to be delivered by the judges, 6 months prior to the actual judgment, the result was there. All the 7 judges are going to give the unanimous judgment that equality but separate was inequality. Equality means equality. Equality but separate means when there are 4 first-class compartments in a train, 2 first-class compartments are meant for whites, 2 first-class compartments meant for blacks. Blacks are not allowed to travel along with the whites. So that was the discrimination. In the elementary schools started for blacks separately, whites separately. The black student was not allowed to study in the school meant for the whites. Brown versus Board of Education. Brown, a black student who wanted to get the admission in white school, was rejected the admission. Then he went to the Supreme Court. So there, 6 months before the actual judgment, the jury matrix showed that now the judges are in a position to understand equality means equality, equality but separate is inequality. So that type of jury matrix is there. The American realism. Now, in India there is a tremendous scope of research to study the Indian realism. There is no textbook, there is no book, there is no researcher who did research on Indian realism. The reason is a lot of things are there. But the other day also I mentioned about this. You take Justice Krishnaya, you take Justice Channapari, you take Justice Bhagavati. So in the rudimentary stage of developing this public interest litigation, when public interest litigation was started, Justice Hidayatullah and Tulzafurkar bitterly opposed that system. When a regular litigant coming to the court, at the cost of the regular litigant's time, why should you allow the public interest litigation? Some criticized it as paisa interest litigation. Some criticized it as publicity interest litigation. But ultimately, of course, S.P. Gupta versus Union of India in judges transfer case first, it was constitutionalized. Public interest litigation is authorized by the Supreme Court. So why I am telling all these things? Now the judiciary, represented by learned people like Lakshmana Rao garu, so many judges are there, judicial officers are there. The continuing legal education, of course, the judiciary also recognized it. So once a law was there, a person was appointed and given the responsible post, it is not sufficient. It is a continuing legal education. So through the various training programs for every month and every 2 months, judicial academies are there, National Judicial Academy was there, is there, and state judicial academies and all these things are there. So that's why in the process we should all know about the developments. So why we are comparing the American judicial system, American legal system? Because more or less we adopted the constitutional supremacy, we adopted the judicial process, judicial review from American model. So what are the Indian problems? Americans are also seriously thinking the cultural aspects of the Americans. 2 days back I attended one American embassy meeting where the cultural meeting, they had all these problems. So they are also understanding the real social, economic and political issues of the country. The reason is the problems faced by the Indians may also be faced by the Americans. Small example, the Indian culture, Indian marriage system. When marriage is over, wife and husband having 1 or 2 children, when there is a dispute, wife leaves the husband's home and coming to the parents' home. In America, practically, Americans, the team is working 28 cases from Andhra Pradesh, 22 cases from Telangana, where mothers brought their children when the dispute arose to India. But the children was born in America, the child became the American, child became American citizen. So he is an American citizen. So under American law, squarely it comes under kidnapping from the country. So of course the discussion was also there in a small meeting. So Hague Convention discussed about all these things, where India was not a member to the Hague Convention. Now how to solve these problems? So the American embassy has this particular problem to solve this, because in India we have mother is the natural guardian. So there is no wonder when mother takes the children from the father when there is dispute arise. But in American context, conflict of laws. So all these are very, very important issues to be understood. And as a law student, you should also know all these things. And Justice Lakshmana Rao garu obtained his PhD from Andhra University, and he is continuing his legal education. Even now he is the present scholar, LLD scholar of DSNLU. So we are fortunate Justice Lakshmana Rao is our LLD scholar. So I welcome Justice Lakshmana Rao to share his thoughts with us.